The state is asking for a final order today to finalize a temporary order that was done back in August of this year. Should make the court aware that this case, yes, was originally done in Hidalgo County, but then it got transferred to here in Bell. The temporary order, as brief background, it appointed Mr. Maldonado Perez as guardian attorney ad litem, ordered Mr. Escobedo to email his federal income tax returns for 2023 and 2024 to the state. Name the parties joint managing conservators of the new child, in this case, Azil, Javier Escobedo. Put the parties on app close. Gave Mr. Escobedo some electronic communication. Ordered both parties to get drug tests as instructed by Mr. Maldonado. Mr. Escobedo's gross monthly resources were calculated at the time to be $2,291.67. Support was calculated based off of 3 children in this case and 0 out. Neither party had access to private health insurance or private dental insurance. Mr. Escobedo was ordered to pay $103 each month beginning August 1st, 2025 for the cash medical. And he was also ordered to pay $572 each month beginning August 1st, 2025 for the current child support. There is a special provision in that where the court reserved the right to order current child support to begin after either the date of his answer to our original petition or the date when he was served with said original petition, whichever date's earlier. State understands that he never answered. So at least as far as the state understands, he was served on January 6, 2025, with our original petition and also the motion to transfer that we did back then. The court reserved non-disclosure for Ms. Cantu for final hearing. The visitation was standard position order with exchanges at the Belton Police Department. As for today, Your Honor, I think we can all agree on, me, Ms. Cantu, and Mr. Escobedo, that the gross monthly income in the temporary order is accurate at the very least of what he's getting. State understands that Ms. Cantu believes he makes more than that. And State has some images that she had sent us and that to try to prove that up. And Mr. Escobedo, I'll have to ask him if you know. Let me slow down, Your Honor. The state got the income tax returns from Mr. Escobedo, and they showed that for 2023, let's see. Sorry, it takes a while to load these images up. For 2023, his annual gross receipts or sales is 31,200. State understands that he's a sole proprietor for a cabinet business. And then for 2024, it was the gross receipts or sales was 25,000. And Your Honor, if we average the two together, divide by 12 to get the gross monthly, it comes out to bring pretty close to what the temporary order says. 2,342 versus, let's see what the temporary order said. $2,292 about. So he's asking at the very least to keep it at that. But like I said, State understands Ms. Cantu believes he makes more than that, and she will be able to talk about that. State understands that Ms. Cantu is asking for retroactive child support. You started current support, Your Honor, on August 1st, 2025. So the day before that, July 31st, 2025 would be the end date. State understands that Miss Cantu believes that the parties no longer living in the same household on August 18th, 2023, although I'll ask Mr. Escobedo if that's about correct. And if it is, then that would be the timeline we'd be looking at. And I'll calculate that, Your Honor, based off what you tell me. And we'll do the guideline percentage. Guideline percentage for 3 in and 0 out is it's 30%, and then 2 in, 0 out, which was what the prior order did, was 25. So we'll do 30 minus 25. I believe Ms. Cantu may also talk about the fact that there was no support ordered back for those 2 kids on the last order. That would appear to be a deviation due to them living together and having reconciled, but that's obviously not the case anymore. So I understand that she says that he has made no cash or very expensive goods to her for the benefit of Azil. And I'll ask Mr. Escobedo if that's what he says as well. So he's not asking for the health or dental insurance to change from what's in the temporary order unless Ms. Cantu has access to do private insurance. So he understands Mr. Escobedo does not. And Your Honor, when we do retroactive support, Your Honor, if the court does order it, State would also like to take a judgment for the arrears, and State has also provided the financial report for that as well. And that's it.
All right. Thank you, Mr. Welch. Mr. Maldonado Perez.
Yes, Your Honor. Today, we would be requesting a modification from the temporary orders on terms of visitation. We did comply. I did comply with the order of the court, and the 2 parents did test a hair follicle. There was Mr. Escobedo was tested positive, and based upon that is my decision to make a recommendation of changing the visitation. I would be requesting, first of all, that the test results are admitted into evidence, which I submitted to Ms. Molina earlier for today. And I would like to recommend supervised visits of the father, either by the mother or somebody she designates, based upon that test. And other than that, the kids really enjoy the time spent with the father. It's just the issue of the drug use. But I think if the mother has the ability of receiving a negative drug test before the dad comes to visit the father, that would be make everybody feel safer and the kids more secure that there's nothing going on. And that would be my amendment from the temporary orders that I would be requesting today. The kids are fine with the mother. The mother tested negative, and there are no issues on that end. I did do a criminal check on both the parents, and they have no record anywhere. So that's what I would be proposing today, Your Honor.
Thank you, gentlemen, very much. Let's go ahead and get the party sworn in, and we'll start the witnesses, and we'll take it from there. I'm gonna go ahead and tell you what, I need 1 minute to take care of the person to help me put the new chair in here, and we'll get started in just a moment. Thank you. Let's get back on the record, and I'll let you start calling your witnesses. So we are now officially back on the record. Now the recorder will work. All right, there we go. We're now officially back on the record on Bell County cause number 25 DFAM 352079. Now at this time, I'll allow Mr. Welch to call your first witness, please.
Thank you, Your Honor. I should note for the court before I begin calling, just because I know this can be confusing, at least for me. So the visitation and conservatorship, essentially everything but the money, and the yeah, everything but the current support, that's just for Azil, the new child, like the changes, like the joint main conservatorship, the visitation, electronic communications. That's just for Azil. The current supports for all the children because we're essentially modifying for all of them. The retro is just for Azil. I thought I would just clarify that. I have no issue, Your Honor, if you want to change the visitation and stuff for all three of them. But I thought I would let you know what we had pled for.
All right, then, no problem. Go ahead and ask both Mr. Escobedo and Ms. Cantu to raise your right hands. Ms. Cantu, if you can turn on video, please do so. And everybody raise your right hands and I'll get you sworn. Thank you. All right, do you both solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you?
Yes.
Do you so swear, sir?
Yes.
All right, you're both officially under oath, and I'll allow the state to call you as witnesses, and you may proceed at this time, Mr. Welch. Thank you.
Thank you, Your Honor. So state calls April Cantu. What is your full name?
April Francis Cantu.
All right. What are the full names of the children in this case?
Andrew Escobedo, Andrew Xavier Escobedo, Armaya May Escobedo, and Azel Javier Escobedo.
All right. So when was Andrew born?
Andrew was born July 15, 2014.
How old is he?
He is 11.
When was I apologize for mispronouncing this. Armaya? When was she born?
Armaya, she was born September 15, 2017.
So how old is she?
She is 7.
All right. And when was Azel born?
November 15, 21.
So when was Azel? How old is Azel then?
He's now 3. He'll be 4 on the 15th.
So Azel is the child that we're newly adding now.
Yes.
So what health insurance are all three of them on right now?
Medicaid.
Do you have access to private health insurance for them?
Currently, no. My office is, I think they're trying to get us health insurance, but currently, no.
And then do you have access to private dental insurance?
No.
A state offers what is marked as State's Exhibit B, the financial report, Your Honor.
Order, here we go. All right, folks, this is State's Exhibit B. This is the financial activity report in your case. Mr. Maldonado Perez, any objection to this coming in evidence?
No objection, Your Honor.
All right, either party have an objection to the financial information coming in evidence at this time?
No.
No.
All right, state please admitted, you may proceed.
Thank you, Your Honor. So Ms. Cantu, do you what do you want? Well, do you agree with the current child support that has been that the court put in place in the temporary order of $572 each month beginning August 1st, 2025?
No.
Why don't you agree with that?
I believe that he is making more than that.
So how do you know this? How do you know this?
Just based off of how we were living when we were together, and once we separated, he started moving things around and things like that.
When did you two no longer live in the same household together?
That was, I left the house August 18th, 2023.
Your Honor, may I share my screen for state's proposed Exhibit C so I can ask Cantu questions about it to prove it up?
Yes, you may. You
All
should,
right.
co-host, you should be able to do it automatically.
All right. And then this should be, all right. So can everyone see this?
Yes, we can.
Yes.
All right. So let's start off with, do you recognize these cars here?
Yes.
What cars are these?
Those were mine and Julian's vehicles while we were together.
And
And there are one or two that are not posted there, but those are the main vehicles that we had.
so are these images of these cars accurate representations of the cars that that he has?
Yes.
And then what is this?
That's just something, that's a brand new barbecue pit, a crawfish boil and a Blackstone. I just put that there to show we were very stable and
Well, so
able
are
to
these
spend.
owned by Mr. Escobedo?
They were bought while we were together, but he currently has them at
Where
in
does he
Edinburgh,
have these?
Edinburgh, Texas. The house that we own together.
State offers would have marked as State's Exhibit C.
All right, real quick, ma'am, do you and he still own that residence together, or is that in his name, or what are we talking about here?
That's still under both of our names currently.
All right, then. And before I get it, I'll tell you what, let me go ahead and see whether or not there's any objection. Mr. Maldonado Perez, any objection to state C?
No objection, Your Honor.
All right, and Mr. Escobedo, any objection, sir?
Yeah, I don't have any of those cars anymore.
All right, so that's not an objection. That's just telling the court the circumstances. But is there a legal reason why the court should not allow this into evidence, sir?
Yes, because they haven't been, those cars haven't been around since 2022.
All right, then, sir. Your objection is overruled. State C is admitted. You may proceed. Again, sir, that was not a proper objection. I'm sorry. Anyway, ma'am,
Yes.
as far as the you and the father own this house jointly, how do y'all own this, ma'am?
How are we? I'm sorry, he's currently living in the house.
Yeah.
When
Let's say
it
both
came
your names.
under both of our names, but he's currently living in it. And I'm living here in Bell County.
All right, ma'am. And then have you seen the appraised value of that property at this time for 2025?
I have not seen the appraisal. I haven't got the updated appraisal.
All right, okay, just trying to make sure because it should have been, you should have had it by now. You know,
Okay.
we'll get that from him. Thank you. Ma'am, the last time you saw an appraisal from the county, how much did they value this property at, please?
I don't have that document on me. I don't have that on me.
And you don't recall?
No.
All right, thank you, then, ma'am. You may proceed at this time, Mr. Welch. Thank you.
Thank you, Your Honor. So the house that he's currently living in, was it bought or was it constructed?
It was bought. Mhm.
Have there been any like renovations on it?
Yes, we completely renovated the inside of the house and we completely renovated outside. We put new skirting, concrete all around. We made a carport. It's completely brand new from the inside out.
When did these renovations take place?
We started, I'd say we moved in 2020 and we've just been renovating since today. Even today, he's renovated that house.
And how do you know that he's renovated it even today?
Um, well, I don't have proof, but just the kids say certain things.
Okay, ma'am, you can't testify to something someone else said, only what you, only things that he has told you or that
Mhm.
you're not witness to. Thank you.
Okay, well, the last thing that we renovated and updated was the carport.
And when was that?
Oof, I'd have to. I don't have the date on that.
Year?
But it was in 23.
All right. And before or after you separated?
Before.
So how much, like, you don't need to give an exact figure, but how much did have these all these renovations cost?
Um, I'm not. I don't recall. I don't know.
Ma'am, are y'all
Um,
legally
uh, Jonah,
Ms.
did you say
Cantu,
something?
Just because while Julian and I were together, he did handle all the
All right,
most
ma'am.
of the finances.
All right, ma'am. I'm just wondering, are y'all legally married?
Not legally married. We did consider ourselves, I guess, common law married.
All right, you good. All right, then.
But
I'll go with that information in a moment, but for right now, but y'all are not legally married. Okay,
no,
thank
we
you.
are not legally married. No.
All right, then. But formally married, I'm sorry, you're legally married, maybe the wrong moniker to use on that if y'all are common law. So at this time, I'll let the state proceed. Thank you.
Thank you, Your Honor. So what does Mr. Escobedo do? What does he do for a living?
He's a carpenter with this company.
This company, he an employee of it or does he own it?
He, I believe, owns it.
What is the name?
Julian's Cabinets.
And how long has he had this company?
He's had the company. Armayo was say 2019. I don't remember the year, but around there.
Are you asking for retroactive or back support?
Yes.
Do you have any concerns with Mr. Escobedo knowing your address, phone number, things like that, now and in the future?
Yes.
Um, has Mr. Escobedo ever physically assaulted or verbally threatened you or the child or the children?
No.
So, what concerns do you have then with him knowing that information?
I would just prefer to have that private. He knows where we currently live. I've told him our address, but just in the future, I mean, I would like to have that to myself.
Has Mr. Escobedo given you any cash or very expensive goods for the benefit of Azil from basically August 2023 to July 2025?
No.
Pass the witness.
All right, thank you very much. Mr. Malone Perez, you're a witness.
Yes, Ms. Cantu, what concerns do you have with regards to Mr. Escobedo's visits with the children?
My concerns is that he tests negative for his drug screenings.
Okay, but not after you've known that he tested, but before you knew that, what were your concerns?
I've known that he's been using drugs. That's the reason why we left. So that has always been a concern. A concern with him also is I guess the way he communicates with me um, is very disrespectful. There's no respect there or anything like that. As you can see, he's laughing. But I would just, I don't know, I would want to keep it with that communication app that we have. And I'm not too sure if the judge is able to read those text messages. I now know that I have to bring that in to be seen. I thought the judge was able to just pull those messages himself. Um, but yeah, I
Okay,
would for all
and
of it recorded.
but he's the father of the children,
Hmm.
and it's 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 good for the children to know who their parents is, correct?
No, yes, I
Okay,
completely agree.
and and you would not oppose some kind of visitation so these children know who the father is, right?
Right. I've let the kids visit Julian multiple times.
And they do enjoy the visits when they go
Yes.
with the father.
Yes.
And I've talked to them myself, and they've told me so. Okay. Now, this drug use, it is a concern. So, what would you like? How would you like to handle this situation about the drug issue?
I would want him to be drug tested um, every time he comes and visits the kids.
Okay. And
And
what
I don't know
the
if we're able to, but anybody who comes with him, um, if they could
No,
also be drug
no, ma'am,
tested.
no, ma'am, you can't go
Okay.
there. Thank
Okay.
you.
Then just the father. Yeah.
okay. Okay, so if somebody comes with them and would you be is there people in his family where he lives, where it's my understanding his family lives down there and your family too, right?
Yes.
Do you have trustworthy people down there that can supervise visits with the father?
There, I'm not too sure, just because, and I can't prove it, but, he does have family members that also use, um,
Yeah, but I'm talking not about anybody. I'm talking about somebody you trust. Are there people down there that you trust could supervise your children?
no, not down there, no.
Not even your family that lives down there?
I wouldn't.
You,
Hmm.
so so if the father has to have supervised visitation,
Hmm.
it would have to be only under your supervision then?
I would, I would be okay with that. Or if I can choose someone, but the visitations be here in Bell County.
Yeah, but if the children are you could actually allow the children to go down with the father if you have somebody supervising, maybe.
Okay.
Uh uh you're telling me you don't have anybody that could do that.
I could, I mean, I can see. So this person that I supervise, if they sleep, they would have to sleep with near the children also, right?
Yes, yes, that would be the idea.
Hmm.
Okay, so you would be agreeable to have supervised visits by the father uh and that he is tested before the visits.
Yes.
So he can send you evidence of drug testing to you.
Yes, but how would that work? Like, would it be in a hotel?
You don't get to ask
Okay.
questions back at this point. No, thank
Okay.
you.
Okay. All right. And would that take care of your concerns about the drugs?
Yes.
Okay. I have no further questions, Your Honor.
All right, thank you very much. Anything on redirect there, Mr. Welch?
No, Your Honor.
All right, then. All right, thank you very much, ma'am. We'll be back in just a moment. You can call your next witness, Mr. Welch.
Thank you, Your Honor. State calls Julian Escobedo. What is your full name?
Julian Escobedo Jr.
All right. So, do you have access to private health insurance for the 3 kids?
No, sir.
What about private dental?
No, sir.
All right. Would you agree that on your on the income tax return for 2023 you sent me, the total for gross receipts is 31,200,
Yes, sir.
and then for the 2024 income tax return, 25,000 for the total gross receipts.
Yes, sir.
All right. So what do you do for a living?
I work for my father's cabinet company,
And what is this company called?
Julian's Cabinets,
And how long have you been working there?
since my dad opened it in 2020. 2021, sorry.
So are you telling the court that you don't own this company? You work for someone else?
I work for somebody else. My tax return is a 1099. He pays me based on the work that I do. I'm basically self-employed.
So then I would ask you, sir, why does the income tax returns that you sent me have the Schedule C profit or loss from business sole proprietorship then?
Because that's self-employment. He doesn't, like I said, he will give me a job that he gets, and however fast I do it, that's what I get paid regarding on. I don't have a name to a company. It's Julian Escobedo Jr., my tax return.
So how many buildings does this business have?
One.
And how many vehicles does this business have?
3.
So when did you and Miss Cantu no longer live in the same household together?
17 of 23.
So August 17, 2023?
Yes, sir.
So do you live in an apartment or in a house?
In a house.
Is this house the same one Miss Cantu was talking about that you two bought and renovated?
Yes.
Do you own any other real property?
No, sir.
How many personal vehicles, not from the business, do you own?
None.
So has this house been renovated?
Yes.
When did you begin renovating it?
In 2019 when I bought it.
And is these renovations still going on?
No, they're not.
When did the renovations end?
In 2022.
approximate figure, how much did these renovations cost?
like $80,000.
And how much did the house cost?
For 18,000.
18,000 for just buying the house?
The house and the land, yes, sir. It was a family friend that sold it to me. That you can
Uh,
see all that on the deed.
So,
I bought the
what is your
house for
highest level of it?
17,000.
Wait, sir,
Just a
Bill-
second, sir. No, just stop and let the state ask the next question. Thank you.
what is the highest level of education you have?
High school.
Do you have any special licenses other
No, I
than
don't.
driver's license?
No, sir.
So, have you given Miss Cantu any cash or very expensive goods for the benefit of a zeal between August 2023 and July 2025?
Yes, sir. I submitted those to you, to your email.
And Your Honor, I can say that he had just while during this hearing sent me some
I had sent them
Zelle
before.
receipts uh, s- with payments to Miss Cantu among others. And Your Honor, I counted up how much. Well, I counted up how much the receipts to Miss Cantu during the retroactive time period. Um, would you like me to give that number, Your Honor?
Yes, please. Thank you.
Uh, that number is let's see, 2,648. Now, Mr. Escobedo, these payments that you are alleging that you have made, um, uh, were they specifically for Azil?
For all my children. Zale being part of that. And that's because one of my banks couldn't give me all the Zelle receipts.
Okay, here's the deal, sir. You answered the question. If the state wants you to explain the information, they will ask the next question, sir. But you've answered already. Thank you.
All right. Do you have any concerns with Miss Cantu knowing your address, phone number, things like that now or in the future?
No.
So, you said that you said you had 3 cars in your business and no private cars. Do you recall when I showed Miss Cantu and y'all those photos?
Yes, I do.
So how do you explain the discrepancy on that? Because there was a lot more than 3 on there.
Yeah, those cars, I had them when I worked for that other company.
What other company?
I used to work for a company out of Houston. We talked about this on the first hearing. But that's what I'm saying. Those cars, all of them are already gone or crashed, or none of them exist anymore.
All right. So when did you stop working at this? Well, I guess to begin with, are you still working at this Houston company?
No, sir.
When did you stop working at it?
In 2021 or 2020. I don't know the last day, honestly.
And so, when did you start? When did you start working in this business you're currently in right now?
When I left them, I don't know the date. I want to say it was October of 2021 or 2020. I can't recall.
As a witness.
All right, thank you. Your witness, Mr. Maldonado Perez, thank you.
Yes, Mr. Escobedo, do you have concerns about the children being with the mother?
Yes, I do.
What are those concerns?
The concerns are my children always complaining about her leaving them alone.
Stop. Sorry, here we go. Just like I told the mother, sir, you cannot testify to something someone else says. You can only testify to what you're an eyewitness to or what the mother has told you. Understood? Don't tell me anything the kid said. Don't tell me anything that even her mother told you something about her. You cannot testify to that. You got to get them to come in and testify as witnesses, sir. So only what you know specifically and what she's told you. Thank you.
So what are those concerns that you have personal knowledge?
Nothing I can prove.
Okay. Now, I share with you your drug test results. Are you
Yes, sir.
okay? Now, Your Honor, I would like to request the admission of Litem exhibits 1 and 2.
Technically, they got business record affidavits that are properly done, so they're automatically admitted. So that's not a problem, sir. 1 and 2 are admitted. Thank you.
Thank you. Now you were, as you could see in those tests, you were positive for cocaine,
Yes, sir.
right? Now, when was the last time you used cocaine?
Like 2 months ago.
2 months ago. And how often do you use cocaine?
It just depends. It's like on a night out or something, which is like once a month.
And where did you get this cocaine?
Just find it from just there at a restroom bar or something.
Okay. And do your friends use cocaine with you?
No.
You do it by yourself?
Yes, sir.
Okay. You don't do it have you ever done it in front of the children?
No, sir.
Okay. Are you, do you think is good for the children to be with you while you are high on cocaine?
I've never been high on cocaine with the children.
Okay. So at what time do you do it then that the children are not there?
If I go out on a night when the kids are not here.
So it's a social thing?
Yes, sir.
Okay. And I have no further questions, Your Honor.
All right, thank you. All right, anything on redirect, Mr. Welch?
Not for Mr. Escobedo, although I would like to ask Your Honor to recall Ms. Cantu to ask her about the price of that house.
Okay, then. All right, I'll ask Mr. Escobedo. You've received the county assessments for the property taxes and for that house for 2025. Have you not, sir?
Yes, sir.
All right. What's that assessment say the value of that home is this time?
89,000.
All right. Thank you, sir. I'll let you and if you need to send a copy of that over to the state or the ad litem, you wouldn't have a problem, would you, sir?
No, I have to find it, but no, that wouldn't be an issue.
All right, thank you. Yeah, well, we could probably dig it up too just by going online, but yeah, it just depends on how easy it is to get. Yeah, every county's a little different. Anyway, thank you very much, sir. So at this time, I'm going to let the state recall the mom, and we'll be back to you in just a moment, sir. So at this time, Mr. Welch, you could recall Ms. Cantu. Thank you.
Thank you, Your Honor. So, Ms. Cantu, I mean, how much did the house cost to buy it? That and the land, let's just say. You're muted, ma'am.
Around what Julian stated is correct. 18. I do have that paperwork also.
That's fine, ma'am.
Mhm.
Pass the witness.
I also have.
Okay, stop now. I'm sorry. There's no question right now.
Mhm.
Mr. Amado Perez, any other questions of the witness?
No, Your Honor.
Okay. All right then, folks, I'm gonna let you both, I'm gonna let the state make a closing statement, let the Atlanta make a closing statement as far as requests that they are requesting. And then I'll give you each the opportunity to tell the court anything else that you think I need to know going forward. And I'll give you a couple of minutes on that each. And then the court's gonna have to try to make a decision based on what I have before me at this time. In fact, so at this time, I'm gonna go ahead and let y'all tell the court the information y'all think I need to know. And I will let, and again, you cannot testify to anything you don't, you're not an eyewitness to, or anything that the other person didn't tell you. So at this time, ma'am, I'm gonna start with you, and then I'm gonna go to the father, and then I'm going to allow the state and everybody make a closing, and Mr. Manuel Perez make a closing statement or closing request. So at this time, Ms. Cantu, anything else that you think the court needs to know based on the testimony you've already given here today? Let's not go somewhere else. But is there anything else that you think I need to know that didn't come out in the general hearing, ma'am?
Yes.
What do you think I need to know, ma'am?
So I do have paperwork here of the vehicles that are pictured. One of them is a 2012 Ram 3500 that we got in 2020.
Okay. Yes, no, ma'am. I could only look at the items. The court usually doesn't look at anything that's more than 10 years old because they don't have a blue book. They don't have a value under blue book any longer. And I would need getting values on vehicles more than 10 years old are problematic. So do you have any, first off, are any of these vehicles 2015 or older, younger than that?
Younger than 2015. The
Yeah.
oldest I have is 19.
Okay, so you have one that's in 2019?
Yes.
Okay, and what vehicle is that, ma'am?
That was his Yamaha motorcycle bike.
Okay, motorcycle. Okay, anything else?
No.
All right, then. All right, now, ma'am, go ahead and tell the court anything else you think I need to know. Thank you.
No, Julian, he did, call child services on me. And I have the paperwork here that everything is ruled out.
All right, when did that take place, ma'am?
When did this take place? This was July 14th, 2025. And before this, he did call Troy Police Department to my house around 11 o'clock for same thing, stating that the kids are being neglected and abused. And they're both false accusations.
All right, thank you very much, ma'am. That is definitely relevant because under the Texas Family Code, it's given CPS or officers to come out under false pretenses that can affect custody, visitation, so forth and so on. Thank you, ma'am. Anything else?
No, that's it.
All right, sir, your turn. Again, it's got to be relevant. It's got to be pertinent. So at this time, anything else you want to tell me?
Your Honor, the only thing that I ask is for the pickup and drop off to be met halfway, and that she lets my older children speak to me on their own cell phones that I provide. Those are the only two of my concerns.
Okay. All right. Thank you very much, sir. One's more doable than the other, but we'll go ahead and let the state and the Atlanta make their closings at this time. Thank you. You may proceed with your closing statements at this time, Mr. Welch and Mr. Maldonado Perez. Thank you.
Thank you, Your Honor. So, Your Honor, the state is asking for a final order. Ask for appropriate rulings on conservatorship, visitation, app close, and then I asked for an appropriate ruling based on the evidence for non-disclosure. State understands that Mr. Escobedo wasn't asking for it. State understands Ms. Cantu was asking for it. The initial reason being that she just wanted it to be private, and then I think later on then just now she's listed some other things. I won't take a side on that, Your Honor. And then as for the current support, it appears that neither party have access to private health or dental insurance at this time. So state asks the court to continue the government medical. State understands that at the very least, we all agree that his gross monthly, at the very least, is about what's in the temporary order, $2,291.67. State understands Ms. Cantu believes it should be higher than that. And she has discussed that. I asked the court to at least keep the $103 per month for the cash medical. That's in the temporary order, along with the $572 to the current child support. If you want to increase that, Your Honor, I'll defer that to you. And have that start probably be best December 1st, 2025. And then, Your Honor, Ms. Cantu is asking for retroactive support. So I understand the timeline is going to be about, they were pretty close, August 17th to August 18th. Basically, August 2023 through the month before current support started in August 2025. So August 2023 to July 2025. It appears that Ms. Cantu says she received no cash or expensive goods for the benefit of Azil. And during that time period, and that Mr. Escobedo disagrees. And I've already said to the court, I added up all the total payments that I could see to Ms. Cantu. It didn't say anything about whether it was just to Azil or in general, although he has testified that that's for all three children. I asked the court to make.
I heard that, and I was probably going to give him credit for 1/3 of that. So yeah.
And then and so I'll calculate retroactive support if you would like me to, Your Honor, based on what income you give me. I can certainly use the amount that's in the temporary order from 2023 on, but if you want to go higher, I'll defer that to you. I just realized now, Your Honor, and I apologize. I would like to ask Mr. Escobedo if he has any other children. I don't believe he does. He didn't have it back in the temporary order, but probably best to ask anyway.
Please confirm that at this time. Thank you.
Mr. Escobedo, how many, besides the three children in this, besides Andrew, Armaya, and Azil, how many other biological or adopted children do you have?
None.
All right. And I'll use for the retroactive guideline percentage, I'll use 5% because that's 30% for 3 in 0 out minus 25% of 2 in 0 out. And then, Your Honor, we do a judgment. Probably best to do it as of yesterday, November 6th. According to the financial report, he's currently in child support arrears of $1,393.24. $393.24.
Okay.
And his medical arrears are $309.52. So essentially, we would just we keep the medical arrears as they are, set a repayment on those. State recommends $52 per month. And then for the child support arrears, we would add whatever retro you grant to those child support arrears and do a cumulative judgment with a cumulative repayment to that. And that's it, Your Honor.
All right. Thank you very much, Mr. Welch. Mr. Malvo Perez.
Yes, Your Honor. These children really like both their parents. They really enjoy being with the dad, and they really enjoy being with the mom, and they're safe and have a suitable place where living conditions where they are. Now, due to the drug testing that we received, I think it's in best interest of the children for the dad's visits to be supervised by the mother or a third party who she designates. I think we can continue with the same first, third, and fifth weekends, like in the temporary order, like it was before. And also that the father should submit prior to the visit a drug test stating that he is clean and he's not doing, under the influence of any drug. We would like to request that. We think we don't, it is my belief it's in the best interest of the children not to be with somebody that is involved in drugs and must be clean. That would be the amendment I would like to request on the temporary orders at this time. And I would, because of those conditions, I would say that the father should have to come pick up the children at their home.
Okay.
That would
All
be
right,
all,
good.
Your Honor.
All right, thank you very much, sir. All right, folks. Anything else, sir? I'm sorry. Mr. Perez, anything else?
Nothing else, Your Honor.
All right, everybody.
I did have something to say. I wanted the retroactive for all 3 children.
I mean, there's court orders, so that's a problem, okay?
Okay,
The
well,
court orders still control.
I would ask for, I mean, at least once I left the house with the children, I would prefer that once we left the house.
Okay, well, again, ma'am, I'll have to look over the prior court orders from Hidalgo County and double check everything, but you may not be eligible for that, ma'am, all right?
Okay.
Thank you.
Your Honor,
Yes, sir.
I also just want to state that she can't be the one supervising the visit due to when she hit me in the head and the cops were involved, so
Okay, here's the
I
deal, sir.
cannot be in a room with her.
Stop. Has Ms. Cantu been convicted of any act of family violence against you that you're aware of, sir? Criminal conviction.
The state had
If I
picked
may,
it up.
Your
I don't
Honor.
know what happened.
I'm sorry.
If I may, Your Honor, I did a criminal record check on both of them, and there's nothing on record.
Okay, that's what I got over here. So again, sir, everybody in this country is innocent until proven guilty, and there's no proof of guilt. Then and so, okay, sir. Here's the deal. I can set up an agency that you'll have to pay to have visitation with your kids. Do you want me to do that?
I cannot afford that, Your Honor.
That's what I know, sir. So again,
Yeah,
I got set up visitation, and you're the one that used the cocaine, sir. You're the one. That's on you.
Yeah, that is my fault. I understand that.
So
Her
again, if I
mother,
accept somebody to do it, do you have a third party, somebody in her family that you wouldn't mind?
her mother, sir.
Okay, but her mother lives where?
She lives here in McAllen, Texas.
Okay, see, that's the problem. So, all right then. Here's what I'm looking at doing, folks. I gotta go. I'm gonna have to sit here and go over all this. I've got absolutely nothing this afternoon, so I'm gonna sit as soon as I go get another cup of coffee, grab some lunch. I'm gonna come back down here and sit, and I'm gonna make a ruling. Sir, you allege that you have not had cocaine in the last 2 months?
Yes, sir.
All right, then that might give you a little leeway to get something done before there's the 30 days is up in the with me making a ruling and signing off on this case, so that I can actually do something if I need to. But anyway, I got to do some research on what test I can get that shows that the level of drugs in your system have gone down over the last 90 days. So that may require you taking another drug test, sir. But anyway.
Yes, sir. Would you want to speak to her mother just to confirm that she would be okay with the supervised visits and going over there with me and picking them up and all that? Is that something that you need to do?
That would be your responsibility to take care of this, sir. I don't do that sort of thing. It's up to parties and their counsel to get that information before the court in the manner they see that the parties of their counsel think is most appropriate.
Okay, Your Honor.
Mumbo jumbo to say, sir, it's up to you to get that information to me.
Oh, so how do I send it? Do I send it over to you now?
No, sir, I cannot tell you how to practice law. Right now, we're through with here. You would have to call her as a witness, and right now, I'm getting ready to end the hearing, sir.
Yes, sir.
Okay.
I thought I was designated to choose someone to be,
Sir, no, ma'am, I have not given that designated.
or,
Yeah, that's my, again, that's my choice, ma'am.
yeah, okay, I just wanted
So
to,
right now, the state is requested, right now, it's look, the norm is it would be you, all right?
okay.
And it's left up to, and if he's gonna do it, he wants an alternative, then he's gotta give the court the appropriate alternative. All right, folks, I'm gonna go ahead and let everybody go. Mr. Welch, I'm gonna go ahead and, like I said, I'm gonna finish this one up myself. I'm gonna look over everything we just went over. I'm gonna look at the testing again. I'm gonna do the research to see if there's something that I can do over the next 25 to 30 days before this thing becomes final, to see whether or not drug level use has gone down and the father system is well. Again, I know that's a possibility. I just that I have not looked into that in this matter. But for right now, I'm going to go ahead and reset this matter for a ruling. Well, what's the next time? I'm going to have a ruling ready by this evening. So let's see. All right. All right, folks, the next general docket day I have for this for bail for this county is the 13th. In other words, 6 days from the day. But I'm going to go ahead and have a ruling to send out, to be ready to send out this evening or this afternoon after lunch. But if I don't formally need to get a ruling on the record, I'm going to go ahead and reset this matter for 9 a.m. on the general docket on the 13th of November, and no one has to appear. Lawyers, parties, no one. This is just to get the ruling on the record. But I will have a ruling by the end of the day, and I'll get that out I'll get that out to the state, and the state can forward it to your email addresses, and I'll get it out to Mr. Maldonado. So is there anything else from and I'll start with the parties again, and then I'll go to the two lawyers, and I'll take it from there. So with that on the record, I'm going to go ahead and make a formal ruling by the end of the I'll get that out today, but it will actually go on the record next Thursday at 9 a.m. after docket call. Is there anything else that you need at this time, Mr. Welch?
So Your Honor, I guess first thing is that so for the retroactive support, will you be calculating that, or like how would you want, if you do order that, like how do you want that addressed, Your Honor?
I'll calculate it, sir.
All right.
And give I'll give you the dates and the amounts for credit, and then you can give me the final amount, sir. Okay.
Yes, Your Honor. And I will. All right. And then Your Honor, like I said at the beginning, if you and the parties want to make it so that the conservatorship and visitation are applied to all three children, not just Azil. I mean, I have no objections to that, Your Honor. So I understand the court probably wouldn't want to do restriction on just Azil, and then the other two be covered under that whatever old order they're covered on.
Right. Now, the old order controls as far as those other two are concerned, and then, like I said, the modification will bring everything up to date as far as all three are concerned. That's the way it should read.
Well, I mean, if we look at the temporary order, like as far as the state's concerned, Your Honor, we pled to add due conservative visitation on only Azil, and then do all the money changes on all three except for retro.
Okay, yeah. So the Zill's the only one we're dealing with as far as conservatorship concerned, and but the modification as far as child support and everything else is going forward for all three, correct?
Yes, Your Honor, except for visitation, that's also just for Azil.
Okay, all right then. So the old visitation order for the okay, so the old visitation order under the old order is also in full force effect. Y'all didn't ask for any type of modification of that?
Not on our plating, Your Honor, because the state doesn't have interest in that. I can try to find out. Well, it should be in.
All right, well, I'll tell you what, look like a judge. I'm gonna go back and read we have to redo all the pleadings and see what the original order said and see whether or not the court can make any type of changes for his visitation for the older two children. Otherwise, I might just be dealing with the youngest child, which is not the way it should have gone. It should have been done, but the office down in down in that county, yeah, well, they did what they did. So again, I can only do what has been planned for, and I'll double check it. I thought everything was up for grab. So that's the norm when you actually add the added child actually updates everything as far as all three children is concerned is the norm. So I'll have to double check that then. And I'm sorry, I missed it. Just thought that was the circumstance in this case also. So.
Your Honor, if I may, I think if a dad is not safe for one, it's not safe for three. And this court should consider modifying both orders.
I mean,
all right. Go ahead, Mr. Welch, because again, if that's the case, then we may be operating still under further temporary order so the matters can be replayed and set up properly. Because again, I thought that's that's the normal way it's done. Oh yeah, you get these pop-ups.
well, Your Honor, that's what I'm thinking is maybe, if we all agree to do it as to all three, then that's a trial amendment, and that can, that'll work even if,
I'll let
that,
you make a trial amendment. I'll go ahead and make rulings. But again, I may have to do some other items to make sure it's all in compliance with the rules. So if that's the child amendment that Mr. Maldonado Perez has just made that and I'll take that as his request for a child amendment. And but I may have to do something totally different as far as the time frames are concerned based on that, sir.
I understand, Your Honor. I'm just pointing out what our petition says.
Okay.
So,
all right. Okay. All right. Anything else then, sir?
No, Your Honor. So you'll still have the ruling sent out tonight, and then if it's not done, then we'll reset the matter for the ruling only hearing.
Go ahead and reset it for that for 9 a.m. on the 13th automatically. But I'm going to go ahead and get a ruling out this afternoon.
Yes, Your Honor. All right.
Again,
and then I'll follow whatever instruction.
I'll formally put that ruling on the record at that time, okay? But the ruling will go out before then.
Works for me, Your Honor, and I'll follow whatever directions on the retro you give me and in your email. So.
Okay, thank you. All right, everybody, the court's getting ready to again have to. I'm gonna go ahead and take care of this afternoon and get it out and go back over all the data and go back over all the pleadings that again, it's my mistake that the pleadings did not cover what I thought they covered, and I'll have to make orders appropriate to the pleadings that are before the court, and any type of trial amendments or request of the attorney ad litem and the state and the parties. So anyway. So at this time, I just said a lot of stuff that people who even have gone to law school may not get. So do you have any questions at this time, ma'am?
Yeah, I have a question. So, we're not sure if we're doing retroactive for the two older children. So I don't know.
I'm probably absolutely sure, ma'am, we're not, but go ahead.
Okay, I mean, I just have statements of me paying Ralph Wilson in after school care since May of 24. And each month it's about $300 to $360 a month. Daycare for Azel is $290 a week.
Okay.
So those are just some things that for you to consider. I mean, that's just childcare that I'm paying.
That again, we're dealing with retro. It's got to be very specific. We're going forward. I can do pretty much anything I need to above and beyond, or below, or below or beneath. It's left up to the court on that one.
Okay.
All right, sir. Any questions on your part?
No, Your Honor.
All right, everybody. Like I said, the court's getting ready to go ahead and like I said, grab some lunch, grab a cup of coffee, and I'm coming right back to this file, and I'll get everything out this afternoon. Thank you. Everybody be safe out there, and we're off the record. Thank you. Thank you, Mr. Maldonado Perez. Thank you, Mr. Welch. Thank you, Mr. Escobedo. Thank you, Ms. Cantu. Thank you.
Thank you.
Thank you, Your Honor. So Mr. Escobedo and Ms. Cantu and Mr. Perez, I'll be the one drafting the order from this. It'll be sent through DocuSign. You'll get a chance to sign. If you don't sign, it'll still be submitted, assuming Mr. Perez signs. But I will give you a chance to sign and read over it. And we'll do a notice of hearing for the 9 a.m. general docket, November 13th. So y'all can peer through Zoom if you want, but as Judge said, you don't have to.
Docket call, usually the court doesn't take up the first matter until about 10:15 anyway. So y'all come in at 9 o'clock, you might be sitting around an hour no matter what, because I got to call the docket of everybody else who's there, go over the morning announcements and all those other items that go along with a regular docket call. I know y'all had to sit through those before, so you know what I'm talking about.
So that's about it. Have a good day, everyone.
All right,
Mr.
thank
Welch,
y'all.
can you give us a call once the judge submits the order to you?
You'll
Well-
send, I'm sorry, who you talking to? You talking to Mr.
To
Perez?
Mr. Welch.
Mr. Welch is going to send you a copy of the order once he goes ahead and sends it, turns it into an order, sir. If you want a copy of the ruling, he can send that along if you wish. But again, it's the order controls, not the rule, not the letter ruling. All right.
Yes, sir.
Thank you. All right.
Have a good day, everyone.
Thank you. Give her a few minutes and we'll wait, and if not, then we'll start at 1:15. Thank you. All right, so at this time, court's going to go ahead and call once again. Bell County calls number 23 DFAM 352,079. This is in the interest of Escobedo minor children. Again, Mr. Julian Escobedo Jr. is the non-custodial party, and Miss April Cantu is the parent with the right to decide domicile. So at this time, I'm gonna go ahead and make my rulings as far as the modification is concerned. Reset this matter for specifically that purpose. As I already stated earlier, I'm going to order that the parties remain and communicate exclusively through app close going forward on all aspects of this order, and that includes any information exchanging about the children or anything else concerning the kids. Everything has to go through the app close. If you do it by a third-party method, your regular cell phone and or email or anything like that, it will not count as being in conformity with this court order. Again, I'm going to go ahead and at this time find that the information provided by Mr. Escobedo as far as his current income and information the court is finding is, I'm going to find that information is unreliable. His testimony that he's now making a third what he used to make 2 years ago, 2.5 years ago, before he's not finding it viable. He's self-employed. It's a family business. So at this time, I will find that obviously people can start making less money, but I'm not going to go with the amounts that he is saying. I'm going to go ahead and find that the amount that the state originally figured out for the court, based on 22.5% at $1,340.23 is the amount that I will initially look at. However, since the court will give them the benefit of the doubt on not making somewhat less money, at this time, I'm going to, instead of ordering $1,340.23 in child support going forward, I'm going to go ahead and start the first day of December and order $1,140.23. I'm going to go ahead and find that the court is going to do a rounded off of retroactive child support for the new child, and I'm going to go ahead and put that at $5,200, and I'm going to order an additional $50 a month payment toward that. I'm going to go ahead and find that based on the father's positive drug test for cocaine, I'm going to go ahead and grant limited access to the children. I'm going to go ahead and allow electronic visits twice a week, on Sundays at 6 p.m. and on Wednesdays at 6 p.m. But all visitation, all electronic is either by voice or FaceTime function through app close. Mr. Escobedo, you have to give the mother at least 24 hours advance notice that you're going to do your visitation. So if you're going to do the visitation on Sunday, she needs to know by 6 p.m. on Saturday that you're going to do it. And if you're going to do it on Wednesday, she needs to know by 6 p.m. on Tuesday that you're going to do it. Ms. Escobedo, if you have, I know the kids are in school, there are school functions. If there's ever a school function on a Wednesday, then you need to let him know, and it'll automatically transfer to the very next day, Thursday. But we're going to try to, there's not a lot these days, hopefully, with children this age. So, but again, if there needs to be a change because of some type of school function, then it will go to the very next day at 6 p.m. But for right now, it's every Wednesday and every Sunday for electronic visits. I'm also going to go ahead and find, based on until further of the court, and sir, that means the court will want to see a hair follicle test that shows no drug use before I go start looking at doing some type of standard visitation or a visitation where you're allowed to pick the children up. But for right now, I will allow you also to see the children at least once a month on a live circumstance, but because of the distances, this is just not going to be practical for me to use. The mother doesn't want to do it, and I can understand why. So I'm going to go ahead and order that you have to use a third-party visitation center to do visitation once a month, sir. When you can do it on either the first or the third Saturday of the month. But you got to get mom on that at least 7 days advance notice that you're going to do it. And we're going to go ahead, and the court is going to go ahead and allow you to do visitation with the children through a supervised visitation facility. And at this time, I'm going to go ahead and order that be the Access Supervised Services. They're out of they're out of Travis County and Williamson County. They're located right near I-35. So, sir, here's the deal. If you want, you can see your children at this facility if you pay in advance. They charge so much, and you need to pay in advance, and you can pay. You can get up to 2 hours, or you can get up to 3 hours there if you're willing to pay, sir. And they will provide someone to chaperone the visitation and provide security for the entire visitation time frame. Ma'am, you will be ordered upon 72 hours advance notice that he has secured that facility for visitation on either that third or the first or the third Saturday of the month. The time frames he has secured it for, they require a minimum of 2 hours. If he wants to go up to 3, he can, but again, it's going to cost him to do that. And he will need to send you verification and a receipt that he has secured that facility, and you will be ordered to get the children to that facility. Again, this was right outside of, right between, looks like Georgetown and Round Rock, but it's that's the closest one coming down from from his area. And because in Bell County, the only one we have is out in Killeen. So I'm not going to have him come all the way out to Killeen. I'm going to go ahead and use the one that's closest to you, ma'am, by I-35. And again, that is called Access Supervised Services. Mr. Amaldo Perez, I've done this all online. I have not confirmed with them that this is they currently still have the same addresses. I got this straight out the AG's information website and the CPS website. So I'm thinking they're still active there, but I want you to confirm that they are. If they turn out not to be, you need to let me know and try to find a facility that again is close to I-35 as possible, somewhere between again in either Travis or Williamson County, that the father can pay someone to have that access. It's still, sir, once you show that you have at least done at least one hair follicle test with no drug testing, then the court will look at with no positive for any type of drug, the court will look at changing you back to some type of visitation where it won't have to be through a supervised center. But until you can do that and file the necessary paperwork with this court to do so, I'm not going to order I'm not going to order unsupervised visits until I see that there are clean drug tests, sir.
But how do I reach out? Who do I reach out to?
I'm sorry?
Who would I reach out to when that time comes?
Then you can file sir, you need to get your own legal counsel on that, but you can file your own pro se request to the court for a change of visitation. You could hire a lawyer to do it, but it's up to you to get it done before the court. Either do it yourself, sir, or you can hire a lawyer to do it. I can't tell you how to practice law, all right?
Okay, and other question is, how are you getting this income? What are you basing that off of? If I
I'm
turn in
basing it
my,
on what
if
you,
I
I'm
turn in
basing it
my
on the
tax
fact that,
return.
here's the deal, sir. I'm basing it on the fact that the last time you were in court, you were found to earn so much, and now the last time that you gave this court information, I'm not going to go with it. I don't believe that you making 1/3 of what you used to make before 2 years ago, sir.
But it doesn't matter on belief, it matters on what the tax return is.
Here's the deal, sir. No, it doesn't. It has on what finding I make. If you argue with me one more time, you're going to owe Bell County $500 fine. All right. Here's the deal, sir. This is a court of law. I don't have you. You can't tell me how to practice law, and I won't tell you how to do what you do for a living, sir. Understood? This is the finding I made. I'm finding that you are either the information is not correct or you are underemployed. Because this time 2 years ago, you were making a lot more money, and now you're going to come before the court and drop this down to a 1/3 of what it used to be. I'm not buying it. All right, and that's my prerogative, sir. And you can go talk to a lawyer about that, and they'll tell you the judge has the right to do that. Understood? So.
Okay.
All right then. And those are my rulings at this time, Mr. Welch. I know that was a heck of a mouthful at this point. Is there anything else you need me to rule on as far as this? Everything else is per the prior temporary order, sir. Is there anything else you need specifically that the court needs to rule on?
So just to make sure, so for the new support, how much will that be? And it'll be starting December 1st?
Yes, sir. It's going to be $1,140, sir. I'm deviating down from the 1,300 that the information that was provided at the last hearing for guideline child support.
Because you find that he is under that, or that he's underemployed essentially?
Yes, sir. That's what I'm going with. Is underemployed, or so he's intentionally underemployed.
Yeah, sorry, Your Honor. I don't remember the 1,300 number I gave you. I guess it's been a while since we've been
Well,
back.
I got documentation, and I specifically, I'll go back to the original order from Hidalgo County, and the court looked at that. Okay, my apologies. I was looking at the 2022 order, but it was the 2020 order that found that based on his income, Mr. Escobedo's, and this may be their information sheet, sir, that came down from the Hidalgo County, that based on his net resources, that his child support should have been set, well, at that time should have been set at $1,344, and that was in 2020, in October 2020. So
Oh, I see that, Your Honor. I see that now.
Okay. All right. And I'm gonna, and for the request that at this, it went down to 0 at one time when they were back together, and there was a different finding, but the court's going to go with the prior finding when he was actually ordered to pay support. And again, I will deviate downward some to give him benefit of the doubt, but again, and based on that and the other information that the mother provided at the temporary hearing, then the court's going to go with this amount for current child support, and the retro at that amount I stated, and repayment at $50 a month. All the cash medical and dental as requested by the state. And is there anything else, sir?
And then court costs, Your Honor?
I'm going to order that Ms. Escobedo is responsible for court costs due to, and that again is based on the positive drug test, and that he's responsible for repaying Bell County on or before the 31st day of December of next year, 2026. Anything they bill him, he's responsible for.
All right. December 31st, 2026. Got it. And then non-disclosure for Ms. Cantu.
Right. She didn't have non-disclosure before, did she?
So the temporary order reserved it. I haven't looked. Let me check the order modifying in 2022. I have a feeling it's not on there because they said they were reconciling. So
right.
Well,
that's the reconciliation order.
Yeah. So they didn't have non-disclosure back in 2022. It's just this last temporary order reserved it. That's why I'm asking now.
All right, well, I'm gonna go, I'm not gonna grant non-disclosure based on the, anything that's happened since 2022. I don't think it's sufficient for, there was not sufficient information for the court to grant that. I am ordering everybody to use app close going forward 100%, mainly due to the mother's request based on says the father's behavior toward her. But I'm not, if she moves, she needs to let him know where she moves to. And same with him. Change phone number, same thing.
All right. And then just two last things, Your Honor. First, that electronic visits are going to be 30 minutes.
Yes, sir.
And then second, write that down. All right, for the live visitation, it'll be the first or third Saturday of each month. One of those.
Yeah, you can pick which one, first or third Saturday. Yes. Upon giving mom, I did say 72 hours advance notice, correct?
Yes.
Right, or at least 3 days advance notice.
And then
Or did
in
I say
that
7 days?
notice, can he send her verification that he is secured? Or like who sends
He has to secure the facility, and he'll get a receipt from that facility that has been taken care of, and he'll need to forward her a copy of that receipt to show that it's been secured, and she's going to be ordered at that point to make sure the children were there. And Belinda said I said 7 days, but I'm going to go ahead and leave it at 72 hours.
All right. Got it. I think that's it, Your Honor. Thank you.
All right, and again, I was going, Mr. Malo Perez, I need you to confirm with that facility that they're still operating at full till they have Saturday visits. And because again, this is all, I got all this from the website. I've used them before, but it's been over a year. It was earlier this year. So, and again, businesses come and go, but I want you to confirm that they're there. And if they are not there any longer, they're not offering those services any longer, let me know. And I'll find an alternate.
Yes, Your Honor, I will find out the information and forward it to the court.
All right, thank you both. Thank you all very much. Is there anything else at this point, Mr. Malo Perez?
Nothing further, Your Honor.
All right, Ms. Cantu, questions?
Yes, I have a question. So I understand once Julian clears the drug testing, then he can start having visitations himself. But what about after that and drug testing? Is he going to be having
First off, he's got to, before it's not an automatic deal. He's got to come back to the court and show the court that he's no longer testing positive and file the necessary pleadings with the court to change that visitation package. At that time, the court will determine what the court wants to do going forward. And every time someone goes out and gets a private test and bring it to me, and every time they brought it to me, I went ahead and ordered my own test to confirm their test.
Okay.
But again, he's got to bring that. He's got to either learn to do it himself, what's called pro se, or he's got to hire a lawyer to come ask the court to modify that based on him no longer testing positive for any type of controlled substance.
Thank you.
All right. All right, Mr. Escobedo, question, sir?
No.
Okay. All right, thank you all very much. I'll let the state prepare that order, and everybody's free to go, and we're off the record. Thank you.
Your Honor, or Mr. Escobedo, or not, sorry,
No,
Mr. Maldonado. How long are these supervised? I think you judge said 2 to 3 hours.
Yeah, up to 3 hours.
Up to
They
3.
charge you by the hour, so it's up to 3 hours, but I think it's always a minimum of 2. At least that's the facility, and that's what I thought. That's what I think I read on their website. But it's up to he can have up to 3 if he wants to pay up to 3, but he has to pay whatever the minimum is. Yeah.
All right, thank you.
Okay.
And so, Mr. Maldonado,
Yes.
just let me know, because I'll be writing up this order soon. If not today, then on Monday. So just let me know, if everything still works for the facility, and then so we can get this everyone signed.
All right.
All right.
Again, specifically,
Mr.
Welch, that the court finds that based on the prior history of this case, that I found that Mr. Escobedo is intentionally underemployed. Okay.
Okay.
Thank you, Your
Uh,
Honor, and
thank
Mr.
you.
Maldonado. Ms. Cantu, I'll be sending it through DocuSign. Everyone will need to sign, and that's it.
Okay, thank you so much. I appreciate.
All right, thank you, ma'am.
Your Honor, may I be excused?
Yes, you may.